Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers taser use, misconduct in office, and blood alcohol concentration tests, and is brought to us by MLive's channel. Be sure to check out the description below and give them the credit that they deserve. On November 13th, 2016, Montmorency County Sheriff Deputy Zachary Morrison responded to multiple 911 calls regarding a pickup truck being driven recklessly in Montmorency County, Michigan. He located the vehicle, which was being driven by Lieutenant Brian Filipiak of the Washtenaw County Sheriff's Office while off-duty, and after witnessing the truck swerving onto the shoulder and then back left over the center line, Deputy Morrison initiated a traffic stop. Lieutenant Filipiak immediately pulled his vehicle over, while Deputy Morrison stopped the cruiser and approached the driver's side window of Lieutenant Filipiak's truck.
Can I see your license, registration, proof of insurance? Okay. You got your ID, your department ID, and your driver's license. The reason why I'm stopping you is we got multiple reckless driving calls about you. Okay. And then when I'm following you, you're hitting the shoulder of the road. You been drinking? How many?
Just a couple.
Okay. Where are you reaching in the back for? I seen you reaching in the back. You have an open container back there?
I did, yeah.
Okay. You been drinking on the way here?
Just going.
Do you have a firearm on you? Okay.
Well,
Do you got your pistol? Are you a corrections officer or just deputy? Lieutenant? Okay. Alright, just sit tight, right back to you. Brian, I'm going to have you step out of the car when I'll do a field sobriety test for you. Okay? I'm going to ask you to step out of the vehicle. What would you like me to do?
just let me go.
I can't. I've got multiple 911 calls about a reckless driver, plate and all matches, almost hitting vehicles. I get behind you. You hit the shoulder of the road twice.
Alright, just let me stay here. Okay?
You can't. I'm going to ask you nicely to step out of this vehicle. Brian, my hands are tied. If I let you go, I'm going to lose my career over you. I don't want to yank you out of this vehicle.
No, just let me go.
I can't. We're done with that. Step out of this vehicle right now.
Just let me go. Be a good guy.
I am being a good guy. Brian, out of this vehicle. I'm asking you nicely, okay?
No, just let me go.
Brian.
I will go sleep in the bushes.
You know, the next thing, I'm going to go hands-on with you.
No,
and you're going to go to jail for R&O. You want that?
No, I don't want that.
Out of this vehicle right now.
Do me a favor.
I can't.
Oh my God.
I'm not losing my career over you.
And I'm not losing my career either, so.
I'm getting done with you.
Alright, what's your name again?
Deputy Morrison.
Morrison?
Zach Morrison.
Just let me.
I can't.
Yes, you can.
You think I want to do this? Arrest a fellow cop?
Yes, I think you do.
Why?
I don't know. Just
I know this career. I know what you go through every day.
No, just let me go over.
Why do you think I want to arrest a cop? We're not above the law.
Throughout the course of the encounter, Lieutenant Filipiak repeatedly asked Deputy Morrison to just let him go so he can sleep it off on the side of the road. Had Deputy Morrison agreed to this proposition, he could have potentially been convicted of several criminal offenses under Michigan law. Under Section 750.478 of the Michigan Compiled Laws, it is a misdemeanor offense for a public officer or any person holding any public trust or employment to willfully neglect to perform their legal duties. And as the Michigan Court of Appeals explained in the 2015 case of People v. Channels, quote, "It is routinely recognized that a police officer has a duty to uphold and enforce the law." In the Channels decision, the court upheld a conviction under Section 750.478 against a police officer who failed to enforce various laws and ordinances that he observed being violated, and similarly upheld a conviction for misconduct in office, which is a common law offense that Section 750.505 of the Michigan Compiled Laws makes a felony. The Channels court explained that, quote, "At common law, misconduct in office was defined as corrupt behavior by an officer in the exercise of the duties of his office, and that, among other things, quote, an officer could be convicted of misconduct in office for failing to perform any act that the duties of the office require of the officer. Additionally, the court clarified that, quote, not only violations of statutory duties are indictable, but also discretionary acts performed with an improper or corrupt motive are subject to indictment. And that, quote, a corrupt intent can be shown where there is intentional or purposeful misbehavior or wrongful conduct pertaining to the requirements and duties of office by an officer. While it is unlikely that Deputy Morrison would actually be prosecuted for either of these offenses if he did not arrest Lieutenant Filipiak, it is at least arguable that doing so would violate these statutes. And, as Deputy Morrison pointed out, showing preferential treatment to an intoxicated police officer could also put his career at risk.
I don't want to fight you.
I'm not going to fight.
You're resisting already.
No, I'm not. I just want you to let me go.
I can't. Out of this vehicle now.
No, be it.
Out of this vehicle
no,
now.
Don't touch me.
Brian, out of this vehicle
no,
now.
Don't touch me.
Let's step out.
No,
you know this.
Oh my God.
Man, don't make me crawl through here.
Get out of this
I
vehicle.
just, hey guys.
Step out to the back and talk.
No, don't.
Out.
No.
We just have to. Out.
Ryan, go. Come on.
No.
You're getting a taser. Back up.
No.
Taser right now if you don't get out.
Make it work, okay?
Out. Right now. Go to the front of my car.
After Lieutenant Filipiak repeatedly refuses to exit the vehicle, Deputy Morrison pulls out his taser and threatens to tase him if he does not step out of the truck. The Supreme Court has not issued a decision regarding when an officer using a taser constitutes excessive force, but as we have discussed before on ATA, it established 3 factors that courts should review when determining whether force is constitutionally excessive in the 1989 case of Graham versus Connor. Quote, the severity of the crime at issue, whether the suspect poses an immediate threat to the safety of the officers or others, and whether he is actively resisting arrest or attempting to evade arrest by flight. However, in applying these factors, lower courts have reached differing opinions as to when a taser may be constitutionally used to gain compliance from a suspect. In the 2016 case of Armstrong versus Village of Pinehurst, the Fourth Circuit determined that officers used excessive force when using a taser on a mentally ill individual who was engaged in, quote, stationary and nonviolent resistance to being handcuffed, and that, quote, tasers are proportional force only when deployed in response to a situation in which a reasonable officer would perceive some immediate danger that could be mitigated by using the taser. In reaching this conclusion, the court reviewed decisions from other circuits where similar uses of a taser were found to be excessive. For instance, in the 2011 case of Matos versus Agarano, the Ninth Circuit concluded that a reasonable fact finder could conclude that officers used excessive force by tasing an individual who actively resisted arrest when she, quote, refused to get out of her car when instructed to do so, and stiffened her body and clutched her steering wheel to frustrate the officer's efforts to remove her from her car. The Armstrong decision also considered similar decisions from the 7th and 8th Circuits, as well as opposing cases from the 11th and 6th Circuits that, quote, distinguished permissible and impermissible tasing based on facts establishing bare non-compliance, rather than facts establishing a risk of danger. The 6th Circuit, which has jurisdiction over the state of Michigan, has upheld taser use as reasonable when an individual is, quote, actively resisting arrest by physically struggling with, threatening, or disobeying officers, as the court explained in the 2012 case of Cockrell versus City of Cincinnati. Therefore, because this incident occurred in the 6th Circuit, a court would likely conclude that Deputy Morrison would not have violated the Constitution if he tased Lieutenant Filipiak had he continued to refuse to exit the vehicle. On the other hand, if this situation had occurred in a circuit that views taser use as excessive if the subject does not pose an immediate danger to anyone, a court reviewing the case would probably reach the opposite conclusion.
You got your firearm on you.
No, I don't.
I'm patting you down. Turn around.
Yeah.
Are you going to do sobriety shots?
134 still with you?
It's affirmative.
Can I just pull off?
No.
Sorry.
If you're not going to do field sobriety tests, turn around, place your hands on your back. You're under arrest.
No, I'm not.
You are under arrest.
No, don't.
You are under arrest. Don't resist.
No.
You're under arrest.
No,
Place your hands behind your back.
No.
Hey, you are placed under arrest for suspicion of operating while intoxicated.
And I already told you I would go by the side of the road and sleep it off, so.
Okay, we're done with that. Backseat of my car, please.
No.
You're already under arrest. Backseat of
Dude.
my patrol car.
Dude,
Brian,
I'm not going to fight you. Can we talk?
I've tried talking. You won't talk to me. You want to sit in the side of the road. You got him?
So, what do we got to talk about?
Well, not much talking about. You know what happens. We're going to take you to the jail and ask for a data master. And if you refuse that, we're going to get a search warrant for your blood. Take you to the hospital and get blood.
Deputy Morrison informs Lieutenant Filipiak that he will be taken to jail and asked for a data master, which is the name of a type of breathalyzer device, and that if he refuses the breath test, he'll get a warrant to take him to the hospital and take his blood. While DUI laws differ between states, there are two primary types of breathalyzer tests that officers use when dealing with potentially intoxicated drivers: a roadside preliminary breath test, or PBT, and a more accurate chemical breath test that's administered at the police station, which in Michigan is the data master breath test. Under Section 257.625A of the Michigan compiled laws, an officer can require that an individual take a PBT if they have reasonable suspicion to believe that they were driving while intoxicated, and the results of the PBT can then be used as the probable cause necessary to arrest the driver. If an individual refuses to take a PBT, they're responsible for a civil infraction, but there will be no criminal charges or points on their driver's license. Once an officer has probable cause to arrest an individual for driving under the influence, either through PBT results or observed evidence of intoxication, they'll be taken to the police station, where they'll be asked to submit to a chemical test of their blood, urine, or breath. While PBTs can be refused without driver's license implications, refusing a post-arrest chemical test will result in driver's license suspension and the addition of 6 points to the driver's record. This distinction exists because Section 257.625C of the compiled statutes, which is known as Michigan's law of implied consent, declares that an individual who operates a vehicle on a public highway in the state is considered to have given consent to chemical tests of their blood, breath, or urine if the person is arrested for a DUI offense. If an individual refuses to submit to a post-arrest chemical test, Section 257.625A requires the officer to obtain a court order, also known as a blood test search warrant, in order to give the test. Notably, in the 2016 case of Birchfield versus North Dakota, the Supreme Court held that while the Fourth Amendment permits warrantless breath tests incident to DUI arrests because the impact of breath tests on privacy is slight, while the need for BAC testing is great, blood tests cannot be administered without consent or a warrant because they are significantly more intrusive. Based on the statutes and precedent, Deputy Morrison would be well within his authority to request that Lieutenant Filipiak take a post-arrest data master breath test at the station, and if he refused, Deputy Morrison could likely obtain a search warrant to have his blood drawn against his will.
Alright, so let's make a deal. Okay?
What kind of deal do you want to make?
A cop to a cop? That's what the deal's about.
A cop to a cop? Why are you putting me in that situation?
Why are you putting me in that situation?
I didn't drink. Okay,
No,
step
let's
back,
talk
step
about
back.
it. No, I'm not going to fight, but...
Have a seat.
No, let's talk about it.
Have a seat. Any other person's going to get an R&O charge. You know this.
I don't know.
Have a seat.
No,
Hey, watch your head.
I'm who you guys are. Do you guys realize that?
Yes.
Okay, then stop.
We're done. Stay right here.
No,
Yes.
just let...
Brian, don't.
Stop. Why are you doing this to a fellow cop?
Why are you doing this to a fellow cop?
After Deputy Morrison took Lieutenant Filipiak to the police station, breath tests showed that he had blood alcohol concentrations of 0.28 and 0.27, which is over 3 times the legal limit of 0.08. Lieutenant Filipiak was originally charged with an aggravated DUI offense under Michigan's so-called super drunk law for individuals who drive with a blood alcohol level of 0.17 or higher. However, on January 27, 2017, he pled guilty to a reduced charge of a standard operating while intoxicated offense and was sentenced to 1 year of probation with a deferred jail sentence. Following the incident, the Washtenaw County Sheriff placed Lieutenant Filipiak on unpaid administrative leave while an internal investigation was conducted. When the investigation was concluded, he was stripped of his titles as a lieutenant and sworn law enforcement officer, but remained employed by the sheriff's office in a so-called support role, which involved managing property, supplies, and equipment, and a number of other duties for reduced compensation. Overall, Deputy Morrison gets an A for maintaining a relatively calm and courteous demeanor throughout the encounter, fulfilling his duties to uphold the law and protect his community without regard to Lieutenant Filipiak's status as a police officer, and for maintaining his integrity as a law enforcement officer. Although some jurisdictions may have found his threatened use of the taser to be excessive, he did not actually deploy the taser, and the applicable case law for Michigan appears to sanction taser use when a suspect is actively disobeying police commands. He also waited until Lieutenant Filipiak had refused to exit the vehicle multiple times and physically resisted attempts to forcibly remove him from the vehicle before resorting to displaying the taser. I commend Deputy Morrison for having the courage to repeatedly refuse Lieutenant Filipiak's continuous request to be let off with a warning, and for possessing the strength of character to avoid any favoritism. Former Lieutenant Filipiak gets an F for endangering the lives of other citizens by driving while extremely intoxicated, failing to obey the lawful commands of the deputy, and for attempting to use his status as a member of law enforcement to avoid being arrested. It is worth mentioning that this incident was not the first time that Mr. Filipiak had encounters with other law enforcement officers regarding his alcohol use. Reports show that there were at least 2 previous incidents in 2013, including a situation where Mr. Filipiak attempted to pick his minor daughter up from the airport while notably intoxicated. Not only did Mr. Filipiak's conduct constitute several criminal violations, but it also tarnished any credibility that he may have held as a police officer. Members of law enforcement take many oaths to obtain their authority under law, such as an oath of office or an oath to the Constitution. Among those pledges, officers swear to an oath of honor, which typically includes the opening phrase, quote, "On my honor, I will never betray my integrity, my character, or the public trust." Mr. Filipiak's actions violated his honor as an officer and endangered the lives of many innocent citizens, and it's surprising that he retains any form of employment within the Washtenaw County Sheriff's Office. Ultimately, Mr. Filipiak was held to some degree of justice, and no one was harmed by his conduct during the time that it went unchecked. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.